If you have been waiting months or even years for your green card and you still have no idea when your turn will come, you are not alone. Every single day, thousands of people stare at those confusing charts on the USCIS website, trying to understand what those dates mean, feeling frustrated, anxious, and completely lost. You hear terms like priority date, cutoff date, final action date, and you wonder why the system has to be so complicated. You see others getting their green cards approved while your case seems frozen in time. You start to question if you did something wrong, if your attorney missed something, or if the system is simply broken beyond repair. I want you to take a deep breath right now because today we are going to break down exactly how priority dates work, why they matter so much for your green card timeline, and most importantly, how you can avoid unnecessary delays by understanding this system properly. No confusing jargon, no panic, just clear facts that will help you navigate your immigration journey with confidence. My name is Umar, and you are watching Real Guide Updates, your trusted source for fact-based immigration news without rumors, without panic, and without speculation. On this channel, we focus on giving you accurate information so you can make informed decisions about your future. So, let us get started. Before we talk about how to avoid delays, we need to understand what a priority date actually is. Think of it as your place in line. When you start the green card process, the system assigns you a specific date that determines when you can move forward with your application. This date is essentially your reservation in a very long queue. The United States has a limit on how many green cards it can issue each year. Congress established these limits decades ago, and they have not changed significantly since then. Currently, the family-based green card system allows approximately 480,000 green cards per year, while the employment-based system allows around 140,000 green cards per year. These numbers might sound large, but when you consider that millions of people around the world want to immigrate to the United States, you start to understand why there is a backlog. Now, here is where it gets more specific. These annual limits are further divided by country. No single country can receive more than 7% of the total green cards available in any category in a given year. This means countries with high demand, such as India, China, Mexico, and the Philippines, often have longer wait times compared to countries with lower demand. Your priority date is the key that determines when you can finally move forward. For employment-based green cards, your priority date is usually the date when your employer filed the labor certification application, also known as the PERM application, with the Department of Labor. If your category does not require labor certification, then your priority date is typically the date when your employer filed the immigrant petition, the Form I-140, with USCIS. For family-based green cards, your priority date is generally the date when your sponsoring relative filed the immigrant petition, the Form I-130, on your behalf. This date stays with you throughout your entire green card process. It does not change even if you switch employers, change jobs, or move to a different state. Your priority date is yours to keep, and understanding this is crucial for planning your immigration journey. Now let us talk about the Visa Bulletin, because this is where most of the confusion happens. The Department of State publishes the Visa Bulletin every single month. You can find it on the State Department website. This bulletin tells you which priority dates are currently being processed for each category and each country. The Visa Bulletin has two charts that you need to understand. The first chart is called the Final Action Dates chart. This chart tells you when a visa number is actually available for you. If your priority date is earlier than the date shown in this chart for your category and country, it means a visa number is available and you can complete your green card process. The second chart is called the Dates for Filing chart. This chart tells you when you can submit your green card application, even if a visa number is not immediately available. USCIS announces each month which chart applicants should use for filing purposes. Here is a practical example to help you understand. Let us say you are from India and you are applying for an employment-based green card in the EB2 category. You look at the current visa bulletin and you see that the final action date for EB2 India shows a date from several years ago. If your priority date is earlier than that date, congratulations, you can move forward. If your priority date is later than that date, you need to wait until the dates advance far enough to include your priority date. This is why some people wait for years while others move through the system relatively quickly. It all depends on your priority date, your category, and your country of birth. Now let us address some common misunderstandings that cause unnecessary stress and can lead to actual delays in your case. The first misunderstanding is that your current country of residence determines your wait time. This is not accurate. The visa bulletin uses your country of birth, not where you currently live or work. If you were born in India but have been living in the United States for 20 years, you are still subject to the wait times for India. If you were born in Canada but moved to India as a child, you would be subject to the wait times for Canada, which are typically much shorter. There is an exception to this rule called cross-chargeability. If you are married to someone born in a different country with shorter wait times, you may be able to use your spouse's country of birth for visa bulletin purposes. This is something you would want to discuss with a qualified immigration attorney, but it is an important option that many people do not know about. The second misunderstanding is that filing your application faster will get you a green card sooner. While it is true that you want to establish your priority date as early as possible, filing quickly after that point does not necessarily speed things up. Once your priority date is established, the timeline depends on the visa bulletin and when dates become current for your category. Filing the same application multiple times or constantly checking your case status does not make the government process your case faster. The third misunderstanding is that priority dates always move forward. Unfortunately, this is not true. Priority dates can move forward, stay the same, or even move backward. When demand is high in a particular category, USCIS may retrogress the dates, meaning they move the cutoff date backward. This can be frustrating if you were close to having your date become current, but it is a normal part of how the system manages demand within the annual limits. The fourth misunderstanding is that if your priority date becomes current, you will automatically get your green card. Having a current priority date means you are eligible to proceed, but you still need to complete the final steps of the process correctly and on time. Missing deadlines, submitting incomplete forms, or failing to respond to requests for evidence can still cause significant delays even when your date is current. Now that we understand the basics, let us talk about specific strategies to avoid delays in your green card process. The first and most important strategy is to establish your priority date as early as possible. If you are planning to pursue an employment-based green card, talk to your employer about starting the process sooner rather than later. The labor certification process alone can take many months, and the earlier you start, the earlier your priority date will be established. For family-based green cards, if you have a relative who is willing and eligible to sponsor you, encourage them to file the I-130 petition as soon as they can. Even if you know the wait will be long, having that priority date established is the first critical step. The second strategy is to monitor the visa bulletin regularly. The Department of State releases the visa bulletin around the middle of each month, and it shows the dates for the following month. Make it a habit to check the bulletin every month. You can find it on the official State Department website. There are also many immigration tracking tools and forums where people discuss visa bulletin movements, but always verify any information you see online against the official source. When you monitor the bulletin regularly, you will start to notice patterns. Some categories move faster than others. Some countries see steady progress, while others are severely backlogged. Understanding these patterns helps you set realistic expectations and plan accordingly. The third strategy is to keep all your documents current and ready. One of the biggest causes of delay once your priority date becomes current is not having your documents prepared. Civil documents such as birth certificates, marriage certificates, and police clearances have expiration dates for immigration purposes. Medical examinations also expire. If you wait until the last minute to gather these documents, you may find yourself scrambling and missing important windows. I recommend creating a file, either physical or digital, where you keep copies of all your important immigration documents. Include documents like your passport, previous visas, approval notices, tax returns, employment records, and any correspondence with USCIS. When your priority date becomes current, you want to be ready to file immediately, not spending weeks gathering paperwork. The fourth strategy is to respond to any USCIS requests promptly and completely. If USCIS sends you a request for evidence, commonly called an RFE, this is not something to ignore or delay. RFEs have strict deadlines, and failing to respond in time can result in your case being denied. When you receive an RFE, read it carefully, understand exactly what they are asking for, and provide a complete response well before the deadline. Many delays happen because applicants provide incomplete responses to RFEs, which leads to further requests or outright denials. If you are unsure how to respond to an RFE, this is a good time to consult with a qualified immigration attorney. The fifth strategy is to keep your address updated with USCIS at all times. This seems like a small thing, but it causes more problems than you might imagine. USCIS sends important notices, interview appointments, and approval documents to the address they have on file. If you move and do not update your address, you might miss critical deadlines or appointments. You can update your address online through your USCIS account or by filing Form AR11. Make this a priority whenever you change your residence. The sixth strategy is to understand your options if your employer situation changes. For employment-based green cards, your job and employer are tied to your application in specific ways at different stages. If you change jobs before certain milestones, it can affect your case. However, there are provisions, such as AC-21 portability, that allow you to change employers under certain conditions without losing your priority date or having to restart the process. The key is to understand these rules before making any job changes. If you are considering a new job offer, take the time to understand how it might affect your immigration case. Again, consulting with a qualified immigration attorney before making major employment decisions is wise if your green card is pending. The seventh strategy is to be realistic about processing times and avoid unnecessary inquiries. USCIS publishes processing times for different form types and service centers. Before contacting USCIS to ask about your case status, check whether your case is actually outside normal processing times. Making excessive inquiries when your case is still within normal processing times does not speed things up and can actually waste resources that could be used to process cases. When your case is outside normal processing times, you do have options. You can submit a case inquiry through the USCIS website or contact the USCIS Contact Center. There are also procedures for requesting expedited processing in certain emergency situations, though these are granted only in specific circumstances. Now let us talk about some specific scenarios that applicants often worry about. What happens if your priority date becomes current but you are not ready to file? This can happen if you were not expecting dates to advance so quickly, or if your personal circumstances changed. The answer is that if you miss the window when your date is current, you will need to wait until it becomes current again. This is why staying prepared is so important. What happens if you filed your application and then the priority dates retrogress? If you already filed your adjustment of status application when your priority date was current, retrogression after filing generally does not affect your pending application. Your application will continue to be processed. However, If dates retrogress before you had a chance to file, you will need to wait until they advance again. What happens if you need to travel while your green card application is pending? This is a common concern and an area where people make mistakes that cause delays. If you have a pending adjustment of status application and you leave the United States without advance parole, your application may be considered abandoned. Make sure you have the proper travel documents before leaving the country. The Form I-131, Application for Travel Document, allows you to request advance parole, and this is something you should apply for along with your adjustment of status application. What happens if your underlying petition is denied or revoked? Your priority date is tied to your approved petition. If the petition is denied or revoked, your priority date may no longer be valid. This is why it is important to ensure your petition is properly prepared and that any required obligations, such as maintaining employment with a sponsoring employer during certain stages, are met. Let me take a moment to address who is actually affected by these priority date considerations and who may not need to worry as much. If you are an immediate relative of a U.S. citizen, meaning you are a spouse, unmarried child under 21, or parent of an adult U.S. citizen, you are fortunate because immediate relatives are not subject to the annual numerical limits. There is no priority date waiting for immediate relatives. Once your petition is approved, you can proceed directly to the final stages of obtaining your green card. However, if you fall into a family preference category, such as being an adult child or sibling of a U.S. citizen, or a relative of a lawful permanent resident, you will have a priority date and will need to wait for it to become current. For employment-based applicants, your wait time depends heavily on your category and your country of birth. EB-1 category applicants, which includes persons of extraordinary ability, outstanding professors and researchers, and multinational executives and managers, often have shorter wait times. EB-2 and EB-3 categories generally have longer waits, especially for applicants born in India and China. If you are in a specialty category such as EB-4 for special immigrants or EB-5 for investors, your wait times may differ, and you should check the specific visa bulletin categories that apply to you. I want to emphasize something important about the information you find online and on social media. There is a lot of speculation about what Congress might do to change the immigration system, what policy changes might happen, or how wait times might change in the future. While it is natural to be interested in these discussions, I encourage you to focus on what you can control rather than getting anxious about things that may or may not happen. Immigration laws are established by Congress, and major changes require new legislation. Policy changes at the agency level take time and go through formal processes. The rules that affect your priority date and visa bulletin have been in place for many years and typically do not change overnight. Any significant changes would be announced through official channels and would not happen as a surprise. When you see rumors or speculation online, take a moment to verify the information through official sources. The USCIS website, the State Department website, and Congress.gov are reliable sources for accurate and current information. Do not make major decisions about your immigration case based on rumors or unofficial reports. For those of you who are currently waiting and feeling frustrated, I understand how difficult this process can be. Waiting years for the chance to build a permanent life in the United States takes patience and resilience. The system has limitations and imperfections that affect millions of people, and your feelings of frustration are completely valid. However, the best thing you can do while waiting is to stay informed, stay prepared, and stay compliant with all immigration requirements. Maintain your current status properly. Keep your documents organized and updated. Monitor the visa bulletin. And when your priority date becomes current, be ready to act promptly and completely. If your situation is complex, if you have had previous immigration issues, or if you simply want professional guidance, consulting with a qualified immigration attorney is a worthwhile investment. A good attorney can review your specific circumstances, identify any potential issues, and help you develop a strategy for your particular situation. Let me also mention that USCIS has made improvements in recent years to their online tools and resources. The USCIS website now has case processing time calculators, online case status checking, and electronic filing for many forms. Your USCIS online account allows you to track your cases, receive electronic notices, and communicate with USCIS in certain circumstances. Taking advantage of these tools can help you stay organized and informed. As we wrap up, let me summarize the key points we covered today. Your priority date is your place in line for a green card, and it is established when certain petitions or applications are filed on your behalf. The Visa Bulletin shows which priority dates are currently being processed, and you should check it monthly to track progress. The wait times depend on your category, your country of birth, and the annual limits set by Congress. Immediate relatives of U.S. citizens do not have priority dates because they are not subject to numerical limits. To avoid delays, establish your priority date as early as possible. Keep your documents ready and updated. Respond promptly and completely to any USCIS requests. Keep your address current and understand how employment changes might affect your case. Stay informed through official sources and avoid making decisions based on rumors or speculation. Remember that due process exists, and immigration rules typically do not change without notice. Major changes require legislation or formal regulatory processes, and you will have time to understand and respond to any changes that affect your case. I hope this video has helped clarify how priority dates work and how you can navigate this aspect of the green card process with more confidence. If you found this information helpful, please take a moment to subscribe to Real Guide updates and turn on notifications so you do not miss our future videos. We release regular content covering important immigration updates, explanations of complex processes, and practical guidance for your immigration journey. If you know someone who is also navigating the green card process and feeling confused or anxious about priority dates, please share this video with them. Clear information helps everyone make better decisions and reduces the fear and confusion that often surrounds immigration matters. I also invite you to leave your immigration-related questions in the comments below. We read every comment and use your questions to guide our future content. Your experiences and concerns help us understand what topics are most important to cover. Thank you for trusting Real Guide Updates as your source for accurate, calm, and factual immigration information. I am Umar, and I will see you in the next video. Take care of yourselves, stay informed, and remember that knowledge is your most powerful tool in navigating the immigration process successfully.